The reason why you're carrying a firearm, I hope, is that if God forbid you ever had to use one, you have it. And if your mind's already gone there, then we need to recognize, as I mentioned before, that there's two deadly force encounters that one happens and is probably going to be over in seconds. That's the kinetic encounter right there at the scene. The second one started years before that with everything you post on social media, everything you tell your friends, the shirts you wear, all of your lifestyle decisions, because all that can be factored into a case against you. And that's, again, that slow moving legal force encounter. Education and training is what you need to be able to compete and win across both of those domains.
So as a kid, training in martial arts and self-defense, all I thought about was the kicking and punching aspect. What will happen when someone comes up to me, what I'm going to do in response, and that was about it. And I think most of us end up doing this more often than we'd like to admit. However, there are other especially important topics that need to be covered when it comes to self-defense, including the legal space. Meaning, more times than not, you may actually have to end up going to court and justifying your actions, even though it appeared that your life was in danger and therefore you were justified in your actions. So as a result, in order to cover the legal topic of self-defense in depth, I brought on Tom Grieve from Grieve Law LLC. And Tom also is a YouTuber covering legal topics on self-defense and Second Amendment. And he has a subscribership of 187,000 at the time of this recording. Tom is an ex-criminal prosecutor who now leads the largest criminal defense firm in Wisconsin, and he's a former instructor, competitive shooter, and relentless Second Amendment advocate. He has also been interviewed and appeared in numerous media outlets ranging from the New York Times, Court TV, Fox News, Reuters, Washington Post, National Public Radio, Milwaukee Journal-Sentinel, and among many others. So with that being said, guys, I can't think of many other people that I've been following in recent years and months that is a better suited person to walk through this journey of self-defense and the legal justice system than Tom Grieve. Let's get into it. Listen in as Tom helps us uncover what it means to use self-defense from a legal justification standpoint in the justice system. Tom Grieve from Grieve Law, LLC. Tom, welcome to the show, brother.
Hey, thanks, Adam. Great seeing you.
Yeah, absolutely. First of all, when it comes to the episodes of podcasts that I've done so far, talking from law enforcement perspective, military perspective, civilian perspective, I was really excited to have you on because one of the things that I think is completely underutilized by civilians as a whole, leading up to and including law enforcement and military, is the legal aspect of self-defense. I think people don't give it enough credit to anticipate and be preparatory in their mindset when it comes to legal. So, if we will, for context, and correct me if I'm wrong, just so the audience and listeners know, the legal, more or less, definition of self-defense would be the justified use of force to protect yourself from bodily harm, injury, or death. Is that correct or not?
I would say for self-defense, yes. And of course, you can roll into it defensive third person. But yeah, I'd say it could be the use of either deadly or non-deadly force in order to stop or terminate a threat against you, physical threat against you.
Perfect. So, one of the things that I want to define as well is one of the things that, for instance, people like Tim Larkin, if you know who that is, and some other different people who are self-defense proponents talk about there being two types, if you will, of physical altercation, which is social posturing and asocial violence. Asocial violence meaning like Uvalde mass shooting scenario, so on and so forth, versus social posturing, which is going to be the people nose to nose, chest to chest, the bravado, the domineering, hierarchy battle that happens in society and across the animal kingdom. So with one of the questions that gets asked to me quite a bit is the idea of, is self-defense justified when someone, for instance, tells you, hit me, I dare you, to give context. I remember years ago as a pup watching the Ultimate Fighting Championship, and of course there's, it's for showmanship, and among other things, they're trying to get ratings, they're trying to get eyeballs. But there was these two fighters, and they got nose to nose, chest to chest. They obviously have some training and experience because they're there. And one of them goes, hit me, I dare you, see what happens. I'm going to knock your teeth in. And some people think that when that person then hits them, they think that they are then justified to fight back and they're going to be okay because he hit me first. Is that true? What is the myth and what is the fact on that? Are you allowed to say something like that and then follow through? What does that look like?
Yeah, so there's actually a lot of things kind of tied together with that. So there's two different concepts. We've got the concept of self-defense, right? And let's just return to that for a moment. So you can use, in the case of a deadly force scenario, you are privileged to use deadly force in order to prevent or to stop, an attack that you believe is going to be reasonably imminent, and it could be deadly in character, right? So you have to be in reasonable fear of imminent death or great bodily harm in order to use deadly force to stop a deadly attack. So in that particular scenario, I'm taking your question to mean that we're probably not in deadly scenario land. Maybe we could be, but it's unclear at best, right? So let's kind of take that self-defense topic and now put that on the side for a moment. The other topic we need to deal with is a topic of consent. So any kind of battery charge, right? We go back to that classic bar fight or, whatever the case may be. Someone just walks up and punches someone else in the street. They're bruised, they're injured. Maybe there's some lacerations or something like that. And typically when we look at the elements for whatever prosecuting jurisdiction we have, you know, the person intended to make contact. So there's a level of intent. That's our mens rea, the Latin term for knowledge. What's our mental purpose? Knowledge, criminal neglect, intent, something else. There you go. So typically for battery charge, we have intent to make contact with, and there's usually some sort of level of harm, and typically there's a without consent. Okay. So, how badly someone's injured will basically dictate oftentimes whether or not we're in some level of felony or some stripe of misdemeanor or maybe even some sort of forfeiture, non criminal violation, as you well know, of course, working in law enforcement. The consent aspect, though, is an important aspect because, of course, I grew up playing ice hockey. Ice hockey's been known to have a collision from time to time. Uh, Football, all sorts of sports, there's collisions. The reason why those are not criminal acts of battery over and over again is because we've all consented. Now, sometimes you do see things. There was a famous hockey incident from 20 some odd years ago where a hockey player just seemingly unprovoked just attacked someone on the ice with a hockey stick and just chopped him down. And I believe he was subject to criminal charges, if memory serves, because that act of violence transcended the game. It wasn't part of we're all stepping onto a field, or in my case, a sheet of ice, and we're all agreeing that we're going to play this game, and the rules of the game limits the violence at X at this particular threshold. And if you transcend that a little bit, okay, that's penalties, right? But when you take that to like 10 levels up, that's something else. So let's bring that back to your posturing scenario. So if you're going to punch that guy, you're going to have to argue one of those two or possibly both, right? And it's going to depend partially what law enforcement is going to come in and charge you with. What your most likely attack is going to be if they go ahead and charge you with a battery charge is, look, he consented to it. This is a consensual encounter, right? He said, hit me. That's a license to, hit the guy. So that would be in the event that they hit you with hit you with that battery charge. Your defenses may, subject to your local laws, always check your local listings. You may find those in that consent territory. But it's also the reason why prosecutors will, as you know, also go after you with something called disorderly conduct and charges like that, where there may not be a consent aspect, namely that you caused a kerfuffle, you somehow precipitated it, it was avoidable, or whatever the case may be, subject to the particular statute. So that's going to be kind of the back and forth, and frankly, some of the prosecutorial strategies to get around that back and forth on that side. When it comes to the self-defense side, look, if you're going to hit someone, you're going to have to be able to show why you were in reasonable fear of imminent death or great bodily harm in the event that you're using deadly force, or the fact that you're still in reasonable fear of bodily harm or whatever the particular self-defense formulation might be in your particular jurisdiction when we're talking about non-deadly force. So how is that guy posturing? How is that going to be an imminent threat against you that you had to act against? And of course, the back and forth on that's going to be pretty simple. The defense is going to say, yeah, he's going nose to nose, jaw to jaw. He's doing whatever, right? Maybe he's bigger, maybe he's stronger. You don't know how he's trained. You don't know how many of these guys surrounding you are his buddies. And maybe you didn't have an exit or something like that. And you don't know if they're armed. So, hey, it just made sense to swing first and try to get out of there in the commotion. Um, as opposed to, of course, letting them strike first or see what happens. So, all that's going to be there. I think generally speaking, throwing the first punch is going to be a weak argument for self defense. I'm not saying it's never going to be there. Really, the context is going to feed the algorithm, if you will, of where we're going to wind up from a jury trial perspective. But more likely, you're probably going to be in that particular scenario a consent based issue, but the prosecutor can usually get around that with a disorderly conduct charge. So there you go. I'm a lawyer. You asked me like a 20-second question, Adam. I gave you like the 5-minute answer.
Sure. No, that's perfect. And in fact, you actually moved into one of the follow-up questions I had, which is almost the inverse. And you talked about hitting first. So there's a thing that a lot of self-defense, self-proposed experts, if you will, or people who are teaching it for a living, that like to claim that there are times where you can actually hit a person first. And you actually brushed on some of the factors for that. Some people call it first strike situation or scenario. Can you just kind of go a little more in depth where that actually becomes justified? Because one of the things that we teach universally is the idea that you assess your environment, you use your situational awareness to assess your surroundings, you try to de-escalate, you try to escape. But then if that escape is unavoidable, you know, are you justified to actually hit first, hit hard, hit fast, run to the house, so to speak?
Yeah, you may be justified, but it's similar to, and I don't want to keep broaching topics on you, but I'm just going to keep throwing things into the pot and see where it goes.
Sure.
Um, it's similar to using any kind of deadly force against an unarmed attacker. It's going to be one of those things where we can certainly build a legal argument for it. It's going to be highly fact specific, intensely driven by pre threat indicators, the context of the environment, and all that kind of stuff. And on a certain level, there's just going to be a lot of people that no matter what are never going to be able to get on board with the fact that you threw the first punch, you
Mm.
shot first, or anything like that. There are just some environments where Han Solo's always going to be the bad guy, I guess. We're going like 80s, 70s Star Wars people, not like, 2000s.
Yeah, gross. No, definitely. I think that's you know super true. In fact, because one of the things that gets thrown at me, and I learned this early on from mentors, is the idea of optics. Optics are super important because you know what's going on. The other person on the other end that you are in opposition with in this situation knows what's going on more or less, but not everyone else who is a witness or paying attention, is going to know what's going on, and they're just going to see what they have with no context. And so, optics being super important. To give an example, I actually, when I was probably in my early 20s, believe it or not, I don't look it, but I'm actually 32 years old. And But in my early 20s, I'm with my girlfriend, now wife, and we were walking. We just got out of the car, leaving the parking lot to enter the city mall. And as we're, entering the city mall, there's commotion. And, this commotion off to the side is probably one, row over. I could see, across the way that there was a female on the ground, probably 15, 16 years old, and another female that was grabbed by a young male, probably a little bit younger than myself at the time. And he had grabbed her, and he then proceeded to punch her and push her down on the ground. And so after that, though, he started walking off and heading towards the mall entrance. And for me, I sat there like, one, I was taught you don't hit girls. That is, what mama raised me on. You don't do that. And so part of me wanted to defend, quote unquote, their honor, or their honor in that situation. So I actually beelined at first for the guy to stop him, to confront him, to keep him there, and then realized as I was approaching him that the situation was over. There was no danger. There was no um, problem at that point. It had pretty much ended. Those girls were getting up, dusting themselves off while this guy was walking inside. And I was actually going to create my own assault and battery situation
Hmm.
potentially as well. And then when I was talked to by, like I said, my mentor, he said, "Hey, optics are important. What does it look like on the Monday newspaper, front page, if you will?" So I definitely agree with the idea that there are going to be people who just from perception look at you and go, nope, you shouldn't have hit first. I don't care what it looks like. I think that's super true. So one of the things that you've talked about though, and I think in some ways this helps avoid that risk, is the race to 911. Could you clarify and define what the race to 911 is, and how that would look like for somebody who had just defended themselves from someone who was trying to assault them at that time?
Yeah. So, as my background as an ex state criminal prosecutor and a criminal defense attorney, and here at the largest criminal defense firm in our state of Wisconsin, we have at any point in time maybe a half dozen, a dozen self defense cases. It ebbs and flows, but that's a pretty safe range, something like that, I'd say. Um, and they're at all different stages of the case. And there's a pretty steady thing that you learn, which is the cases where people do not call 911, either right away or at all, that puts extra problems on our plate. Okay. And I'm going to circle back around to the counter argument of don't call 911. But here's the argument to call 911. It's the optics, building on your earlier point, of what good guys do. Good guys, if the scene is safe, they hang around, they call 911, they take responsibility for their actions, their hopefully righteous and legal actions for what has happened. There's just the optics that bad guys, they run, they get away, they go to ground, all that kind of stuff. So you're cutting against the optics just for starters, and the narrative of how law enforcement is going to view you for better or worse, right or wrong, for how the prosecutor is going to view you for all the same reasons. And should it come to it, the judge and the jury. It's just starting a little bit on the back foot. And again, there may be perfectly great reasons. Maybe the scene wasn't safe. Yeah, get out of there, get safe, right? But again, just as kind of starting like a vanilla baseline case, call 911 stat. Other problems I've seen with cases where people do not win the race to 911, sometimes the bad guys, they call 911. If they're in a situation where they know that there's lots of cameras or someone else probably called, they may try calling 911. And by the way, if they're a bad guy, if they just try to like rob you or something like that or burglarize your house, there's a pretty good chance that they've been through the system once or twice. Not always. Sometimes you get teenagers on some sort of spree trying to like go garage shopping, so to speak, stealing lawnmowers, whatever they can find. Or you get teenage or 20 something year old like drug addicts who are just kind of breaking into homes out of desperation to get drug money. And I'm 0% endorsing that as a lifestyle. I'm just saying there's a distinction between those people versus hardened criminals, right? And particularly the hardened criminal crowd, they're going to understand the buttons and the levers of law enforcement. And I've seen this in any number of cases where the good guy chooses not to call 911, or they don't think the scene is safe, or maybe there's an incident in their car and they're driving to their destination. They figure, I'll call 911 when I get there. Meanwhile, bad guys calls 911, tells the opposite story of this guy just tried to rob me. Of course, they get rid of the evidence, all that kind of stuff. I've got all sorts of stories about that. So again, the system is set up to respond and to try to bifurcate where possible, good guy, bad guy, right? Yeah, sometimes you get co-defendants. Sometimes you've been to enough situations, I'm sure, Adam, where, yeah, there's really no good guys here. They're all just kind of shades of like crummy
Mhm.
decision making, right? But when guns come out, we really try to find a good guy and a bad guy. That's the way our system really tries to operate. And it's not always possible. But you want to make sure that by winning the race to 911, that you're putting yourself firmly in that good guy seat. Now, here's a bit of the counter argument, because we get calls all the time. So we're statewide in Wisconsin. Wisconsin's home to this little city called Milwaukee. Some people call it Kilwaukee for a reason. Some of the most dangerous zip codes in the United States over the years have come from Milwaukee. Milwaukee's no stranger to um, just a lot of the problems that we think of when we think of large major cities. As a result, we get calls from people who had to use a firearm, whether that's just pull out display, whether it's pull out point or pull out point, pull the trigger. Um, and they did not call 911. We get calls from people who say, hey, yesterday night I just shot at a guy who tried to rob me. Okay, number one, are you okay? Number two, are you in police custody? Number three, kind of why aren't you in police custody? Did you call 911?
Mhm.
Yeah, I'm okay. No, I didn't call 911. Why do you think I should? And, we kind of talk through it at that point. It's obviously up to them. It's not up to me. And the the decision making matrix in those kind of neighborhoods can be very different than the decision making matrices in kind of where I live and probably where you live. That's a little bit of a different world, and it's a big part of the reason why a lot of self defense firearm uses, if you just go by CDC statistics and elsewhere, are just frankly not reported.
Mhm.
Most of these people are not calling 911 in my experience. Like they just aren't.
Yeah, that is true. That oftentimes people think, "Hey, I'm okay, no harm, no foul. I can move on with my day. I didn't do anything wrong. I did the right thing." And then sometimes, or maybe they're even worked up emotionally and mentally, and they kind of go into, color code black in some ways, where they just don't. They're so hyper fixated on the fact that it happened, and they are trying to just recover from it that they don't actually go through the proper procedure. So let's actually breach that a little bit and go, okay, you just got done with with a self-defense situation. You talked about how there's good and bad for calling 911, not calling 911. So let's actually go into, if Tom Grieve had to be in a self-defense situation, and let's actually go for, you had to at the very least brandish your firearm in this situation, and now the situation's safe. What are you doing to make sure that you are legally covered and in a good position in that good guy seat, as you put it? What's the first, set of things that you're doing?
Yeah. So, I mean, I'm calling 911 for starters. That's what I'm doing. And another context question is going to be, am I out in the woods somewhere in like northern Wisconsin by myself? And I ran into some sort of like meth head junkie. Or more likely, am I in some sort of suburban or urban setting or something like that? Right. But yeah, number one is I'm assuming the situation's safe and it's clear that there's no ongoing threat. I'm going to be reholstering because I don't need another, whether it's a responding officer or a another good guy concealed carry person. I don't need them perceiving me as a threat because anytime there's a deadly force encounter or anytime there's an incident, there's really two deadly force encounters. You have the kinetic one that happens in the street, in the home, in the car, whatever the case may be, and then there's the legal one. A lot of people don't think of the justice system as a deadly force encounter, but when you're talking about a lot of guys wearing uniforms with guns who can put you away for life or worse, that's a deadly force encounter. And it's just a slow moving deadly force encounter, but it's still a deadly force encounter. So you want to survive both of those, and building your case to survive the second one doesn't start with 911. It starts with education and training, but it definitely continues by calling 911.
Yeah, so let's actually get into that, because that's one of the major questions, and in some ways one of my major complaints about, I guess, the in particular, I'll just put it out there, the gun community. I think that there's a lot of people who carry a firearm, and maybe they're really good at carrying that firearm, but they end up not training past the firearm portion. I mean, for law enforcement, you have different levels of force that you can use. And when it comes to, you know, the low levels of force, whether it be level 1, level 2, and then deadly force, let's say, is level 3, you have those I guess, how do I put it best? You have all these other things that you're supposed to have training experience to do. Is there something for civilians where is that enough to, like, hey, I can carry a firearm and that's good enough for me? Or is there innate responsibility to enhance themselves in a legal perspective of having that training and experience? Hey, I know how to at least do some jujitsu or some boxing or some other things where I can use other levels of force to stop that threat before it escalates to deadly force. I'm getting punched in the face. The guy's unarmed, but he's beating me up. I don't know how to defend myself, so I pull out my gun and I shoot the guy. Um,
Right.
and so is there any sort of, I guess, if you will, responsibility for a civilian to have more than just firearms experience and training? Should they have those other, I guess, mid-tier levels of training for use of force, continuum, or does that actually go against them because they have that training? Where the question then comes, why didn't you use these other options with your training and experience? Yeah, can you touch on that a little bit?
Yeah, one or two things in there. So, number one is anything and everything can be used against you, right? If you get that black belt in taekwondo or jujitsu or whatever it is that you've got, if you have that, they're going to say, "Why didn't you use that?" That's what I mean. That's going to be the argument if you have an aggressive, unreasonable prosecutor. And let me be clear: there's many fantastic, reasonable, level-headed prosecutors who are going to understand why if someone's trying to stab you, you trying to respond with like your yellow belt form from taekwondo and a front snap kick is probably not like your best move at that moment, right? But there's a lot of them who are not going to understand. These are the same people who you see comment like, "Why didn't he shoot him in the knee or something like that?" Right? Like
Yeah.
these people are alive. They've got bar degrees and they occupy DA's offices. So I just want to create that level of a little bit higher resolution on who we're dealing with and the fact that you're going to see some extraordinarily unreasonable arguments and positions coming from prosecutors, but I don't want to paint with a broad brush, understanding that there's a lot of great ones and there's a lot of scary ones. So, with that being said, look, more training, in my view, better, period. That being said, work, kids, whatever else
Mhm.
you got going on, maybe health issues, disabilities, you name it. Getting a black belt in or the equivalent in every single martial arts discipline and carrying a firearm, a flashlight, a knife, a taser, a sap, a billy club, like I mean forget, a force continuum here. Like this is like the Roy G. Biv at a certain point of like we just got the rainbow of force, right?
Mhm.
I feel like there's a trademark in there, the rainbow of force. But right, I mean, the rainbow of force continuum is where that winds up going. There's always going to be arguments, and I've heard the opposite of you don't want to carry less than lethal because it will invite those kind of questions of you have a taser, why don't you try using that?
Mhm.
And of course, you can flip that around, and it's like, well, if you've got a hammer, every problem looks like a nail. If all you carry is a gun, that's what it's going to look like. And the prosecutor will argue either side of that, depending upon what you have. So again, an unreasonable prosecutor, it's like heads I win, tails you lose. That's going to be kind of the gist of that. What I think is this: number one, you have a constitutional right to carry a firearm. You have an ethical responsibility to yourself, to your family, and to your community to get as much training as you possibly can. In my reckoning, those are not mutually exclusive. I'm 0% taking away from someone's right to carry a firearm. I'm not saying don't carry a firearm at all. I'm just saying that the reason why you're carrying a firearm, I hope, is that if God forbid you ever had to use one, you have it. And if your mind's already gone there, then we need to recognize, as I mentioned before, that there's two deadly force encounters that one happens and is probably going to be over in seconds. That's the kinetic encounter right there at the scene. The second one started years before that with everything you post on social media, everything you tell your friends, the shirts you wear, all of your lifestyle decisions, because all that can be factored into a case against you. And that's, again, that slow moving legal force encounter. Education and training is what you need to be able to compete and win across both of those domains. Because I agree, better to be judged by 12 than carried by 6. But how about, not carried by 6, not judged by 12, or a hopefully a very restful, as much as can be, we don't even get to charges or I'm on really good facts. That's what would be great in my world. And unless you're very lucky and we're allowing for the fact that someone like already attacked you. So, your luck, um, unless we're allowing for the fact that you're very lucky, um, I don't want to roll the dice on that. If I'm going to carry a firearm, if I'm going to take personal defense seriously, I'm going to carry the proper tools. And if I'm going to carry the proper tools, I need to know how to use them. And that means the proper hands-on for those. And it means also knowing the law and being trained to be able to handle those situations and the legal force encounters that follow.
Sure. So, speaking of some of the laws, one of the common things that people bring up, in especially in the gun community, is Castle Doctrine. So, with the Castle Doctrine, can you kind of explain for those that don't understand what the Castle Doctrine is, and then where it applies for lethal force versus maybe non-lethal force, such as hand-to-hand protection and so on and so forth?
Yeah. So again, the seams are going to wander, the lines are going to, and boundaries will kind of differ from state to state. But here's the gist of it. Again, in now painting in broad strokes.
Mhm.
So if we imagine the use of deadly force being privileged when you're in reasonable fear of imminent death and of great bodily harm, right? Or maybe it's immediate in your state, or whatever else the case may be. Generally speaking, the Castle Doctrine um, can, depending upon how it's written, create a presumption that if you're in a certain place, such as your home, and if a certain thing happens, like somebody has broken into your home or is in the process of breaking into your home, that a legal presumption is created that you're now in reasonable fear of imminent death or great bodily harm. In other words, I don't necessarily have to wait for the bad guy to like pull out the knife, say, I'm going to kill you and charge, right? I don't have to wait for those shadowy shapes moving through my kitchen to present a weapon. I'm also not suggesting just shoot at shadowy shapes in your kitchen, to be clear. Okay. Target identification all the way. But that's the gist as to how it functioned. Another way that I can see it somewhat interpreted and applied is a little bit of a stand your ground law in someone's home. As to where
Mhm.
it can work, it typically almost always works in your home, not necessarily at your friend's house or anything like that. By home, I mean if you rent an apartment, it can probably work there as well. It can usually work, not always, if you are at a hotel and it's your room for the night and someone tries to break in. It often can work in your own automobile. It can often, but not always, work in your own business. What's your definition of your own business? Check your local listings. You have to be an owner, a manager, an employee, a family member of one of the above. Don't know. Check your local listings and all that. And again, the spirit of all of this, generally speaking, is animated by the concept that we're talking about people defense, not stuff defense. So if your car alarm goes off, you look outside your window in the middle of the night and some guy's like, stealing your ABBA CD, lighting that guy up to save your ABBA CD, that's not going to be Castle Doctrine. That's probably not going to be self defense. That's going to be something very different. That's going to be property defense. So that's not what we're talking about. We're talking about you being in these places when the attack begins.
No, definitely. I think that to your point, if someone's stealing your CD out of your car, I mean, there's nothing for you there. You're not in danger at that moment. Yeah, maybe your stuff's being stolen to some degree, but it's different than like maybe let's say your kid being stolen. That would be something where the level of force used or the immediacy or imminency of danger uh, comes into effect. So because of those factors, because a CD versus a child is different. With cops, as I know you're aware, there's like a force continuum and factors that you look at to regulate how much force you should be using at that time, to make sure that it's justified or not justified force. Is it a recommendation, again, broad strokes, to have civilians looking at the force continuum the same way as cops? Or do they have, I guess, a little bit more leniency because they're not certified in their state and don't have that training as far as how much force they use? To give an example, if there's a person with balled up fists coming towards me, as a certified peace officer, how I would still try to use like less force, the least amount of force necessary to stop that person. But if somebody with balled up fist comes forward in a civilian, then again, we talked about that first strike scenario or whatnot, or maybe they grab them and push them away. Is it more lenient for a civilian, or should they look at it the same way as cops and try to see like, okay, and learn how do cops assess it? Like, can you kind of explain what you think would be best practice, if you will, for
Yeah.
how to assess force?
Yeah. I think that first off, we have to acknowledge that there may not always be the same deck of cards when we're talking about the use of force laws. So
Mhm.
sometimes law enforcement in certain situations can be privileged because of they've you guys have built up a a whole science, let's call it, a sphere of arguments about if this then that. If I'm
Mhm.
trained to see this, then that could be perceived as a threat and so forth. Um, I would say that I, as a citizen, am not going to be getting the same benefit of the doubt in that respect. I think that there's, long story short, I think there's going to be a lot of advantages cutting towards the officer to grant them additional options about when law enforcement can use force. I think there's also going to be other situations where law enforcement are going to see heightened scrutiny about the use of force. The same thing applies to Johnny Q. Public on the street, right? I think that there's different domains and there's different contexts that will drive. If I was a defense attorney and if I saw the fact pattern, do I want my client wearing a badge or not? And I would say probably, 8 times out of 10, I'll probably take the badge as helping
Mm,
me out. Um, just, we're kind of taking vanilla issues here, right? But
sure.
right, I mean, there's just lots of added factors that go in favor of law enforcement, which I'm happy to expand on, but that's kind of my low resolution take.
Sure. No, I agree with you in the sense that there's definitely going to be some advantages or in some ways a perceived benefit of doubt. And so, not to put words in your mouth or misrepresent what you're saying, but what it sounds like is uh, when it comes to evaluating force and whatnot, that's why it almost sounds like it's almost more important for a civilian to expand their knowledge base on how to use force and how to assess threats and utilizing situational awareness and de-escalation. Would that be a correct assessment, or am I misrepresenting you?
That's 100% right. And if uh, if I did half the things that I've seen in police reports, I would have a criminal record, and that is 0% an attacking statement for law enforcement. Let me be
Mhm.
clear. Let me expand on that. What I'm saying is that law enforcement has a different job than I do. My job is to go out to take care of my family, take care of my friends, take care of my community. Um, but I have and my work and so forth. But my duties owed and so forth is going to be very different than an officer who has to arrest a suspect, right? I mean, if I see someone shoplifting, um, I, if I want, I can call the police or notify the store manager and walk away, right? I'm not going to have to figure out, is this person armed? How do I take them into custody? Are they being combative? Are they on drugs and all this other kind of stuff, right? So there's this whole sphere of doing something for officer safety reasons, and a whole set of vocabulary that I see officers use in police reports of. Um, oh boy, what are some of my favorite ones over the years? I horizontally destabilized the subject on the ground. It's like, okay, so you threw him to the ground. I obtained compliance with a defensive strike to the suspect's chest. It's like, so you punched him in the chest and he fell down. Got it. And again, don't misread anything I'm saying. That is 0% an attack on law enforcement. Law enforcement has a very dangerous job, and on a situation by situation case and analysis, these could be 100% be justified.
Mhm.
They could also be entirely wrong, just like civilians, right? It all feeds from the context. But my point is this: the context that feeds into me having a dispute turning into a physical altercation or perhaps worse with someone as me being non-law enforcement, the context that feeds into that is very different than if you, Adam, have a badge, you're on duty, you're in uniform, and now you're in an altercation. That's just a whole different context that's unique, for the most part, unique to law enforcement versus me.
Sure. No, and I think that's well said. It's interesting because you have like I said before, there seems to be this kind of cultural stance, particularly in the United States, where um, guns good, guns bad. I'm going to have my firearm, and I'm going to, I have the right to use it. I have the right to self defense. And then you have the other side that's saying no guns, guns bad, guns kill people. So therefore, we need to take guns, and criminals will follow the law. And I know you've reached on that subject several times. In fact, just recently, you and David Hogg decided to agree on the same subject. or stance, which was kind of incredible. And But as far as the culture, is there anything, I guess, when it comes to force, firearms, and whatnot? Again, keeping this broad, culturally, that you find is misrepresented in self defense for civilians. You know, they come in and they say, "Well, I did this and I did this, and that's what I'm allowed to do that," and then you know your firm has to go, sorry, no. Like, why do people think that that is a thing you can do? Is there anything like that, or is it mostly just ignorance, and ignorance is bliss? So you know, is it ignorance, or is it some sort of misrepresented information that people then grab onto and take off running?
All the above. It's deadly ignorance, it's misrepresentation. People have, and it starts with the justice system. People have profound misunderstandings of how the justice system works, what their rights are, how to raise the right for an attorney, like what does a criminal case look like from A to Z, soup to nuts, front to finish. Like, um, it's Hollywood and the media has concocted a shared fantasy of sorts of this is what the justice system looks like, and it's useful because it creates a very oftentimes compelling, fun, and dramatic portrayal, which, if you've ever been to court, you know has no basis in reality sometimes, because court's usually pretty boring if you're there.
Hmm.
Um, so, uh, there's all these misrepresentations about like what an attorney can do, what we can't do, how that process all plays itself out. There's also lots of misunderstandings about the law. I mean, how many times have you seen someone post online, like shoot, shovel, shut up and stuff like that? And it's like, well, there's a reason why I got the back 40, man. And, stuff like that. It's like, yeah, that's cool. I wouldn't be posting that. I wouldn't be thinking that. Like, I think there's lots of problems with that. That's kind of the path to a felony record, like that mentality.
Hmm.
And it's it's the world that we live in, and that's where we're at right now. And I'm sure we've always been there to some degree or another. But no, people, if you're not trained and educated in how the law works, what's going to happen if you're not properly trained on how to use and survive your tools during a deadly force encounter, your chances of surviving those deadly force encounters just went down. And again, both of them.
Yeah, I couldn't agree more. Honestly, the one of the things that I take issue with is, and something that I found myself guilty with is, I actually recently acquired a new firearm. It's my new, concealed carry, if you want, if you will. And one of the things that I caught myself early on when I first bought it was like, I wasn't doing enough training with it. You know, not all guns are the same. One firearm, if it's a Glock 19 or a Sig P365, it's going to be night and day difference as far as
Mhm.
shooting and the recoil management, how you manipulate the gun. And so I had to kick myself a little bit and go, gosh, I need to be practicing with it if I'm going to be carrying it. That's just important. But one of the things that I wanted to ask you is, you talked about how the news media and Hollywood have kind of skewed a lot of the, expectation versus reality when it comes to the court system and the justice system as a whole, in particular with self-defense. To give an example briefly, not that we need to go down this, but just to give some context of my thought, you have Kyle Rittenhouse, right? Where his whole life was turned upside down, a self-defense situation turned into a really high profile national news, international news story. How much does, and you talked about this, shoot, shovel, shut up, how much does your social media presence and like what you do, what you say, factor into your after effects when it comes to self-defense? Because obviously people are going to comb through your life depending on the level of, I guess, government interest when it comes to the crime. So how much should, people be actually paying attention to their just everyday life and how they act or interact online, in particular when it comes to the legal side of self-defense?
It's all can play a role. I mean, it can all play a role, and it did in that trial. I think there were three different uses of social media and electronics that came up as part of that case, where I'm sure Kyle said, I'd rather get that one back if I could. I'd play a couple mulligans here." And the way the prosecution tried to use that is they tried to use it as shaping what was really going on in Kyle's head and to try to shape the narrative about what was going on that night. Why was he there? What was he doing? And he was basically there looking for trouble, and he was trigger happy and he wanted to shoot people, and he was just trying to get famous, and on and on and on. That was the narrative, obviously, the prosecution was trying to sell the jury. And they used as some of the pieces in that puzzle his social media. And it's basically, it's like starting the game with, yeah, other team, why don't you get the ball to start both the first half and the second half? Let's do that. And I'll spot you a few fumbles along the way. Let's that's just kind of the easy way of conceptualizing this. They're unforced errors. And look, I know what people are going to post in the comment section, which is, well, I've got my First Amendment right. You do. And there's 0% am I taking away from that. However, the prosecution's going to use that against you. That's not my fault. That's not Adam's fault. Okay. That's the truth.
Hmm.
And I'm sorry if you don't like that people can use what another person says and does against them in court. It happens every day. If you don't like it, my suggestion is don't do it. And I'm not saying that's fair, but that is the way it is.
No, I agree with you again. The funny thing is that there's people out there that think, oh, I have, if you will, my right to say things. There's political correctness. There's all these different, so there's people that then, because they see political correctness, they then go, I'm going to just say whatever, and
Right.
even if it shocks the system. Um, and that to me is actually, in some ways, strategically speaking, anti you when it comes to legal, because some of the things you say, obviously, or if not everything, will be used against you, like you said. And so even if you are quote unquote allowed to say it, doesn't mean you should say it. And so as far as it all goes with, I want to kind of move over for to this other scenario where, let's say you are not the one defending yourself. It's actually a third party, someone that you're not associated with. Is there any time where are you allowed to do anything, intervene, or should you just be a good witness? What does that look like when it comes to the, just like you're minding your own business, you see somebody, they're having an altercation, someone's getting the tar kicked out of them. Do you intervene? Do you not? Do you stay out of it? What does that look like?
Well, there's a handful of things. Again, you have to survive the kinetic encounter. You have to force you, and you have to survive the legal encounter. So, when you're talking about third-party intervention, like let's say we're at a Walmart, because just fictionally that, or maybe not so fictionally, that just seems to be where a lot of these examples play out. So, the example I like to give is you're in the meat section, you're at the back of the store, whatever else. You hear some pew pews come in from the front, and you decide, not on my watch, right? And do your tactical strut, past the hot pockets, and
Nice.
all that kind of good stuff, right? And you get to the front, and you see a guy at the gun. Is that another concealed carrier, just like you?
Hmm.
What's he seeing when he sees you, right? So we talked about before the concept of target identification. Well, again, there's going to be an immediate threat that the second you pull out that gun, you might be confused as the bad guy. And I'm not saying don't pull out the gun, to don't try to serve the good. I'm not suggesting that. What I'm simply trying to do is I'm trying to orient people towards the landscape of the risks and problems of what happens here. All right, well, let's say that you do see the actual bad guy and you identify him. He's wearing a ski mask. Great. Okay. Classic bad guy move, right? So he's wearing a ski mask. He's shooting at people and so forth. Great. You do shot. We tend to think we're going to always win the encounter, and just statistically, that's not always what happens. Sometimes you miss, your gun jams, whatever else the case may be, bad guy turns, shoots you. Are you ready for that?
Hmm.
Again, this is one of the liabilities in this very real life situation. All right, let's say you shoot him, you actually hit him, he goes down, threat over. Just hypothetically, it's a Hollywood stop, right? You hit him, it's he just falls over. It's like a Bambi situation. He's done, whatever. Great. Also not the way it works in real life, but fine. Okay, again, now we're back to the first situation. Another guy comes around the corner, sees you holding a gun. Are they going to shoot you? You can ask the Arvada Police Department in Colorado, who, of course, had a mistaken identity situation where they shot the good guy who stopped a bad guy with a good guy with a gun. These things do happen. These are not just hypotheticals that some lawyer on the internet is talking to you about. That's never going to happen. Like this happens. Okay, so these are all things you need to be thinking about and preparing yourself for, so that you understand. I hope if there's anything, my call to action is get training, get education, right? So you know how to cover all that, because we're certainly not going to be able to cover all that right here, right now.
Mhm.
But sure. And then once the scenario goes cold, bad guys down, it's clear for whatever reason that was our only threat, which again, never an assumption you can make. Okay, situation's safe. Are you going to reholster, call 911, all that kind of stuff? I mean, that's the kinetic force encounter. Far more complicated when we're talking about defensive third person, particularly when we're talking about like a public mass shooter event, like what I just gave you there. It wasn't like in robbery where we instantly know good guy from bad guy, all that other kind of stuff. It's complicated, and it can get very messy very quickly in every sense of the term.
Yeah, I think a lot of people don't appreciate the idea that fog of war, if you will, applies to scenarios like what you just shared. I mean, where Mike Tyson would say, "You always have a plan until you get punched in the face." I mean,
Hmm.
it's just the same concept. I mean, and when you get, if you will, punched in the face with this situation where you have a mass shooter, everybody is going to be struggling emotionally, physically. Like your respiratory system is going to go off the charts. You're going to be breathing crazy, and some of us are going to get tunnel visioned. You never rise to the occasion, as they say. You always default to your training. So when it comes to, like, do you think this is advisable? Like for me, I like to have on hand a safety vest. So, as an officer, if I'm off duty, I like to have a safety vest on hand so that I can, if I need to, I can quickly throw it over, have my gun out. So then at least there's something to, I guess, if you will, identify. Is that a decent strategy, or is that something that I should just say, hey, that's not even, like, it doesn't seem that useful? Like, what do you think for that personally?
I mean, I can see the use. It's just what you said. I can see the counterpoint, which is, are you really going to carry this around with you everywhere you go into the
Mhm.
store? Um, Lord knows how a prosecutor is going to be able. I mean, Jesus, if they're already going to be persecuting you while they're prosecuting you because you went out and got a concealed carry license, and then God forbid bought a gun, and then you stuck hollow points inside that gun. Wow, I can imagine the field day, and I have like faces and names that I'm not going to give you of like local prosecutors who I find to be particularly unreasonable. I can only imagine the field day of what they would try to do with that. So I'm not saying it's a bad idea, never do it. I'm just saying virtually every single thing you do, whether you choose to act or don't act, whether you choose to carry a firearm or not, what gun you carry, what you don't carry, how you carry it, how trained you are, how untrained you are, there's always a list of pros and cons on either side. There's just I don't know of a single way or time that there is not a list of pros and cons. In my mind, some of those decisions are black and white. I will this is like, like don't hit on like 20 to me if we're playing blackjack. Like I'm not hitting on a 20 when it comes to, am I going to carry a firearm? Am I going to get educated? Am I going to get trained? That's like not hitting on a 20 there for me. And then it, starts to like shade out into like, yeah, you're gonna get some like close calls where reasonable minds may differ. And a lot of that may also vary depending upon the nature of what your jury pool may look like. What's the nature of your local law enforcement culture, and how oriented are they going to be to a good guy using a firearm in self-defense? That might be very different in a rural area versus a major metropolitan area, for instance, right? And of course, what's the prosecutor culture? And that's, in my experience, less along the lines of politics than you might think. Um, People, I think, automatically jump to the conclusion that if you're in some sort of like blue city, they're going to be all like completely against you. And I would say that that's how the win may start in my experience. But conversely, those people know exactly like what's lurking on those streets, right? So they understand the nature of the threat. You'll find some very reasonable people in there, and you may find some very reasonable juries for you. And you go out into some more red areas where you may just kind of reflexively think, hey, this is going to be a lot more pro gun. And it's like, well, is it? Uh, because if the prosecutors bring charges, their witnesses are going to be cops. And if we're always going to believe cops, if we're always going to back the badge and all that kind of stuff, and I don't take what I'm saying as disparaging. I'm simply playing out, frankly, how this works in real life. Like, yeah, you could have a very red county, and are we going to get the back the badge jury, or are we going to get the libertarian jury? I don't know. Probably a blend of both, right? And depending
Mhm.
on where you're in the country, there are different types of red, and that will kind of shade out and grade in one direction or another. And you can only hope that your prosecutors are going to be reasonable. Your cops are going to be great. They're going to, if you are silly enough to give a statement, that they're going to ask great questions, rather than doing kind of a sloppy half-ass interview, which I've seen before, and it's caused major problems for my client. Um, it's there's so many variables to this. There's so many variables to this.
Sure. So I guess the last couple questions. One, I feel like could be fairly quick, and it kind of goes to your point, which is, I'm a firearms carrier and I want to like swap out my trigger, swap out my slide, bouge out my magazine. I got a magazine weld, all that kind of stuff. Is that ill advised? Like, should you go with like, you don't want the tack light and the red dot sight and everything else that a lot of people like to get, which are all useful tools. Will that actually go against you? Again, you said everything can go against you. You've already established that. You've already established that a prosecutor will take anything they can and run with it to paint that narrative. But you personally, do you carry, like for instance, if you were to carry, do you carry things with like red dots and flared magwells and all that kind of stuff, or do you prefer to carry the, I guess, out of the box, um, gun so that, it's just, that's the way it is. You didn't trick it out because you're intending to shoot anybody, you're not trying to shoot people better. Does which one do you kind of lean towards that's kind of
Yeah,
better for you legally?
yeah. I carry an unmodified 1972 Colt Detective Special. No,
Nice.
um, yeah. Um, so I am okay with weapon modifications, and again, I I realize if you go back even 10 years, and especially if you go back beyond 5 or 10 years, the popular culture, um, the cultural mainstream perception in this 2A community is like never modify your firearm. And if you're going to modify it, like if you're going to take your Glock with a 5.5 pound trigger, put the 8 pound New York trigger in. Like that's the only modify in that direction. And there were perfectly valid and good reasons and fantastic arguments. And everything I'm about to say is not to take away from why those principles were taught. Um, to my mind, though, the prosecutors who are the ones that you're worried about, they have just so radically overplayed their hand where they're going to throw anything and everything against you that, like, you know what? If you need to use a weapon mounted light to get better target identification and isolation, like that makes sense to me, and we can address that with an expert. Is there going to be a price to pay with the juror because you look like you're out of like an Xbox game? Maybe, probably there will be. But again, if that's what you need, God bless. Okay. Yes, I do carry. I carry as religiously as I can. Um, I've been experimenting with red dots and that kind of stuff. Um, I've not gone to any of the closed emitters and that kind of stuff. I'm still I'm in that awkward transition stage. I'm like a 13-year-old when it comes to red dots. It's like, yeah, I can see the benefit. I am shooting well with it, but by the same token, like I just find myself just dumb reaching all the time for like a normal slide.
Hmm.
Um, I do carry a fairly modified firearm, but the modifications came courtesy of Langdon Tactical, in HKP 30 SK LEM. and I absolutely love this firearm. And I used to be a huge Glock guy for God, I don't know how many years. That was like 15 years of being a Glock guy, and I still am. I love Glock, not taken away from Glock, but I've found myself pivoting. I've always been an HK guy. I've always been a Glock guy. I'm a SIG guy in the 22 series. You know, the 200s, the hammer fired 200s. Love those, particularly the older ones. But yeah, you know, I just have certain things that I know work for me and I really like. And there's certain dimensions and rules I've learned that just carry better, at least for me and my dad bod. So I HKP30, SK, LEM, just it's uh it's a pretty sweet ride for me.
Nice. Yeah, right now I'm carrying the just the Glock 43X right now, playing around with that, just because of um, the fact that you can, and then Washington changed its laws quite a bit with magazines, where I wanted to get what was called the shield arms magazines. I don't know if you heard of them, but where they removed the polymer and expanded it so you could get 15 in one. I thought
I've
that was
talked to
pretty
the
cool.
inventor of them. Yes, I'm familiar with those, and I
I,
own a lot of them myself.
yeah, so that's what I was going for, and then they changed their laws, and it's like, I can't get more, and which is unfortunate. But the final question is this, and this one's more for me, but I think it might be beneficial to uh, have the listeners kind of listen in, and I breached on this a little bit earlier, but in the federal government with the Constitution, you have your constitutional rights, the Second Amendment, the First Amendment, so on and so forth. And states are allowed to be more restrictive to where they can protect the citizens even further than what the Constitution allows. However, the Second Amendment is getting attacked left and right with states. I mean, New Mexico most recently is like a big blatant overreach in um, trying to quote unquote use emergency powers to suspend the rights of its citizens. Why is it that all the other rights, like Fourth Amendment, can be more restrictive in favor, but not the Second Amendment? What's the legal precedent for that? Are we ever going to see a change? Can you just kind of talk about it and expand on it?
Yeah. How did we get here? I think is in essence a big part of that question. Well, I think I promise a very short history background. Okay, so we've got the Constitution, we've got the Bill of Rights, the first 10 amendments, right? 1791, all good. What people oftentimes don't know is that those amendments did not restrict the states from doing anything. The Bill of Rights restricted the federal government from passing laws that would infringe on the First Amendment, Second Amendment, all the way through the 10th. But your states could do virtually whatever they wanted. Those amendments did not apply to the states. So
Hmm.
that changed in the late 1860s following the Civil War, where we got the adoption of the 14th Amendment. The 14th Amendment then extended the Constitution and the Bill of Rights and all the other amendments to apply to all of the states. Okay. So it's like, okay, well, late 1860s, we should be good to go. Not so fast. There was a case, and I look forward to getting fact checked on the internet on this, but I want to say it was Cruikshank with a C, like Cruickshank from memory. I want to say it was like 1872, give or take. Which, and I'm happy to know the details of it, but the gist to it was this. The US Supreme Court said no, the First Amendment and the Second Amendment do not get incorporated to the states. So the First Amendment wound up getting incorporated to the states. In other words, it applied to the states so that they could not step on your freedom of religion, your freedom of speech. I want to say that was in the early 1920s from memory. I don't recall the case offhand, but I want to say it was early 1920s. And then, of course, we then had to go almost another 100 years to within the last 15 years post Heller in the McDonald decision, Chicago v. McDonald, which then incorporated the Second Amendment to the through the 14th to apply against the states. Because remember, DC versus Heller, it's in the title, DC versus Heller. So when Heller court said yes, you have an individual right to own a gun and a lot of other key big deal things, then the anti-gun argument is, yeah, well, that only applies in Washington, D.C. right? Because we're not talking about states. They never explicitly incorporated the Second Amendment to the states. So then we had to have McDonald, and then just kind of on we went. But in the interim, between 1872 and, the last 15 years, there's been a fair amount of gun laws. There's been a fair amount of gun control. And as a result, there is a political body and there is a political and governmental culture that has been erected to regulate and see everything over. I mean, can you imagine if we had a bureau of speech, books, internet, and all that kind of stuff, like what we have at the ATF?
Mm-mm.
Um, we have all that now, and we're now living in an era, particularly post Brune, which was the cherry on top of the trifecta of Heller, McDonald, and Bruin. That was the culmination of that. Now we're in a post-Bruin world. And I think it's really unclear to lots of people as to exactly how far the implications of the Bruin court decision is going to go. What does this mean as far as state laws, federal agencies, federal agency power? What's covered by the Second Amendment? Who are the people in the phrase, the rights of the people to keep and bear arms shall not be infringed, right? Does that mean felons, nonviolent felons? Does it mean, adults under the age of 21, between 18 and 21, are they going to be allowed to purchase handguns from a shop, from an FFL? Because right now they're prohibited under the 1968 Gun Control Act. So I remember reading a statistic, and we all know everything we read on the internet's true, right? Um, I remember reading a statistic that said that in the 6 months that followed the Brune decision, so Brune came out in June of 2022. In the 6 months that followed, more gun laws were struck down across the United States in that 6 months than the entire history of the United States combined up to that point. So I think we've got realistically probably about so the U.S. Supreme Court just accepted the Rahimi case, which is really going to fundamentally dive into the question of who are the people. It's not going to address all of our questions, but it's going to be the first case to really speak to that from the Supreme Court. Um, I think we're going to probably see, if I had to guess, maybe if I was forced to put my money into the middle on something, I'll say the Illinois Protect Illinois Communities Act, which is effectively their assault weapon ban and magazine ban. I think that might be my odds-on favorite guess for what's going to go to the court to determine what types of weapons are protected, what types of weapons may not be protected. Are accessories like magazines, are they protected by the Second Amendment or are they not? Um, I think that we're doing this in 2023. I think in 4 years, maybe five on a push, we could win or lose the Second Amendment still. This is
Mm.
super, super up for grabs. Super up for grabs. And whoever wins the next presidential election may be able to sway the court one way or the other, the court that's going to decide these outcomes and decide the future of the Second Amendment. But I think that if we get another 4, 5, 6, and especially get another decade, look, everything can be lost. Everything can always be lost because you can always chip away at rights through incrementalism and all that, right? But it will take decades and decades to undo one way or the other, for better or worse, what will be up for grabs in the next 5 to 10 years, especially the next five.
That's actually super sobering. I mean, to think it's that up for grabs. I didn't realize it was that much on the precipice. I knew it was precarious to say the least, but I didn't know that it was at that level. So I guess I actually have a bonus question to follow up with that.
Yep.
Because
Bonus
people might be
questions. I love
wondering
bonus questions.
what should people be doing to prevent that do they go to their local governments? Like how does that work? What should people be doing to ensure that the Second Amendment, um, which protects all the other amendments, it gives it the teeth it needs, is preserved? Like what should people be doing?
I think you have to get educated, get trained. You need to be a good ambassador. And I think that means that, and this may sound a little strange, but I think it's really easy just to get angry when someone says something we know is crazy, like, "Oh, you don't need a gun. Call the police. They'll be there to, take you off to the morgue and toe tag you up." Um, which is nothing against law enforcement. Again, just we all know it is what it is. deadly force encounter is over in seconds. Law enforcement will be there in minutes. Like, do the math, right? Um, but I think that we cannot just approach things with shall not be infringed, end of discussion. It doesn't have a history of winning in cultural wars. I think that we need to approach this from a position of education, of knowledge, of respect, of charity. I think that we need to be the ambassadors that the Second Amendment deserves, and I think that the future is going to hinge on, in no small part, how involved or what kind of face, so to speak, we attach to it. Because let alone, we all know that the anti-gunners, the civilian disarmament crowd, will do everything that they can to put like an angry face on the whole thing. And this is just about killing people and murdering people. And no, to my perspective, this is a face of empowerment. This is a face of love, of protection, of saving lives, not taking lives. And we have history and we have statistics on our side. And we are doing a tremendous disservice to the Second Amendment if we just say shall not be infringed and act like that's the end all be all. Folks, it's not. We can lose this.
Wow. So, Tom, at this point, because you have so much knowledge and background with the Second Amendment and with the law, where can people find you and learn more about you and just be able to connect with you?
Sure. Well, I've got a YouTube channel, so you can check me out. Just look me up. Just put in Tom Grieve into your YouTube browser, and you'll find it. Otherwise, youtube.com/ATTY. That's the abbreviation for attorney. ATTY Tom Grieve, GRIEVE. We're always putting out content, and it's always fantastic to talk to amazing people like yourself, Adam, who not only through your past and present service to this country and your community, but you're a living example of what you can be doing. You're out there, you're sinking your teeth into issues, you're spreading awareness, you're spreading the message. I guess the last piece, I might get an angry text from Jared from Guns and Gadgets or something if I don't do this, and if for some, if he catches this, get involved with local politics. Talk to your local politicians, talk to them on social media, call them. They have to log all this kind of stuff, write letters. But again, come from it from a position of respect and of education, not of anger and wrath.
Excellent. Well, Tom, thanks for being on. I can't wait in 5 years where we can maybe look back on this and talk about where things have gone, and maybe sooner.
Hopefully.
With that, guys, just be sure to follow Tom. He's already given out the socials. You can also check him out in the description for both the podcast and for the YouTube as well. So, Tom, thanks for being on, brother. Can't wait to talk with you again soon.
Thanks, Adam. You take care.
Holy cow, what an episode. I had such a hard time not wanting to geek out and go into the weeds of the legal side when it comes to self-defense. That stuff fascinates me. The way that Tom breaks things down is very, very, very articulate and very well put together. It's very easy to digest and understand. And he does this continually throughout all of his YouTube videos that he has on his YouTube channel. So be sure to actually follow and subscribe and share the content that he has on his YouTube channel, as that is one of the best places where you can get additional resources or context of what he's explaining when it comes to self-defense and the legal side of things. So with that, guys, thank you so much for watching this episode of the Get Real Self-Defense Podcast. If you enjoyed this video, please be sure to hit that like button, subscribe, and share with your friends and family. And on top of that, if you are listening, please be sure to hit that 5-star review and share it with your friends and family as well. And maybe just leave a comment on what you liked or did not like about the format that we've been doing so far. And with that, guys, train today, protect tomorrow. I will catch you guys next time.